something just came out of the Supreme Court that has gun owners across the country sitting up straight. And no, this isn't a new ban, a surprise law, or some last-minute ruling dropped in the dead of night. It's something far more unusual. A message, a signal, a serious warning that the court rarely delivers so openly, and it's already shaking the entire gun rights conversation. Whether you've owned firearms your whole life or just bought your first one last year, this update is something you cannot afford to ignore. Because what the Supreme Court hinted at wasn't just about the Second Amendment itself. It was about how that right is interpreted, enforced, and potentially restricted moving forward. And depending on how you carry, store, or even talk about your firearm, this shift could affect you starting right now. The reason people are calling this an urgent warning is simple. The court made it clear that the right to bear arms is not a blank check, not a shield for reckless behavior, not something courts will automatically protect if the facts don't line up. And while they didn't take away any rights, the tone, the message between the lines is unmistakable. It's cautioning gun owners to pay attention, stay informed, and understand that the legal landscape is tightening, even if quietly. So the question everyone's asking is, what exactly did the Supreme Court mean? And how will this impact everyday gun owners starting now? Let's break it down. There's a real sense of tension right now in the legal world of gun rights because what the Supreme Court didn't do may be as loud a signal as any formal ruling. Recent developments in Second Amendment litigation, especially surrounding bans on certain semi-automatic rifles, have ignited speculation that the court is subtly recalibrating how it protects gun rights. This isn't a headline-making decision, but it could be one of the most consequential moments for gun owners in years. When gun rights advocates call it an urgent warning, they're not exaggerating. It's a warning rooted in procedural choices, dissents, and the court's refusal to intervene, even when some justices clearly think they should. The foundation for all this is the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. That case rewrote the way lower courts must evaluate gun laws. Instead of balancing public safety goals against gun rights, courts now must ask whether a gun regulation aligns with the nation's historical tradition of firearm regulation. Once someone shows that their conduct is plainly covered by the Second Amendment, the burden shifts to the government to prove that its restrictions are historically justified. That test is powerful, but it's also a narrow one. It doesn't guarantee that every modern gun regulation will be struck down, especially if courts can find analogs in the past. Gun rights advocates rightly point out that Bruen expanded protections, especially for public carry, but the court never said Second Amendment rights are limitless. The justices recognize that some restrictions should survive, those that mirror historical regulations. In practical terms, that means not every gun law is unconstitutional, but the government must do more than argue policy goals. It must show a strong historical justification. That's a big ask. Legal scholars immediately recognized a risk. How consistently will lower courts apply this history and tradition test? Some will lean in gun owners' favor. Others may lean the opposite way. That risk is now coming into focus with cases challenging modern bans on semi-automatic rifles. When the Supreme Court declines to hear a case, it may seem like a setback. But for many observers, the more significant part is how justices respond to that denial. Dissents in these procedural decisions often emphasize that the lower court reasoning may be flawed and signal how certain justices would have approached the case. Even statements that the issue is worthy of review can be interpreted as a warning. The court is paying attention, and the debate is far from settled. Perhaps even more noteworthy is the subtle messaging embedded in these procedural choices. The court is being deliberate, not avoiding controversy, and waiting for clearer opportunities or circuit splits to provide definitive guidance. For gun rights proponents, that waiting amounts to a warning. This is a pivotal moment, and the Supreme Court expects lower courts, lawmakers, and advocates to adhere to the rules it has laid out. If regulation is going to survive under the Bruen test, it needs to be deeply rooted in history. Superficial justifications or purely modern policy arguments will likely fail in court. On the flip side, gun owners should not assume that protections are unconditional. Denials of certiorari mean that current bans remain in force and legal uncertainty persists. The fact that some justices strongly dissent from those denials shows a meaningful division within the court. For gun owners, this is not business as usual. It's a moment of heightened stakes. Every action in the lower courts, every regulation passed at the state level, is being watched and will likely be challenged based on Bruen's historical standard. Advocacy groups have responded with a mix of alarm and mobilization. Gun rights organizations have emphasized the importance of continuing legal challenges and remaining engaged politically to ensure that rights are preserved. They argue that lower courts are applying the historical test inconsistently and that sustained efforts are needed to clarify how modern firearm regulations fit, or fail to fit, within the constitutional framework. At the same time, public discussion has intensified, with legal experts debating how best to argue historical tradition in courts for contemporary firearms. All of this leaves gun owners asking what comes next. One major takeaway is that future litigation is almost guaranteed. The court's current restraint does not close the door. In fact, it may invite additional lower court rulings, creating clearer legal pathways for future Supreme Court review. If enough courts adopt arguments consistent with Bruen and the concerns raised by dissenting justices are considered, the stage may be set for a possible Supreme Court ruling that definitively shapes the scope of Second Amendment protections. Lower courts themselves are wrestling with the application of Bruen, and approaches are far from uniform. Some judges are digging into historical legal debates to find analogs for modern weapons. Others are more skeptical, struggling to reconcile firearms like semi-automatic rifles and high-capacity magazines with historical tradition. That patchwork approach means gun owners' rights could depend heavily on where they live and how local courts interpret history. This uncertainty is more than theoretical. It has immediate practical consequences. States that want to defend restrictive laws face a steeper challenge. They can't simply argue that a weapon is dangerous or that public safety demands a ban. They must show that the regulation has a strong historical precedent. If they cannot, those laws are vulnerable to challenge. At the same time, law-abiding gun owners must understand that their constitutional protections may depend on demonstrating lawful use and understanding the historical legal framework of their rights. This moment is about more than just one type of firearm. It's about how the court wants to define the boundaries of regulation and the responsibilities that come with Second Amendment protections. By signaling through denials and dissents, the justices appear to be communicating that freedom is not unlimited, and that legal defenses must be rooted in history. For gun owners, it's a reminder that rights come with responsibilities, and that lawful behavior and proper compliance will be more important than ever. The broader constitutional conversation involves how much weight historical precedent should carry in modern rights adjudication. Bruen emphasizes originalist reasoning, but this approach carries challenges. Lower courts may struggle to apply the test uniformly, which could lead to uneven protections across the country. This has implications for future cases, advocacy strategies, and legislative drafting. States hoping to defend firearm restrictions must now carefully frame their regulations within historical context if they hope to withstand legal challenges. If the court eventually hears a major case about semi-automatic rifles, magazine capacities, or other firearm accessories, its decision will likely be influenced by the current procedural moment. The justices are sending signals now through statements and procedural choices, which could shape how Second Amendment protections are interpreted and applied for years to come. Gun owners and lawmakers alike are paying close attention, recognizing that how rights are defended today will influence the legal landscape tomorrow. For law-abiding gun owners, the practical advice is clear. Stay informed, stay engaged, and be proactive in understanding both federal and state firearm regulations. Support organizations that litigate Second Amendment cases, monitor how your state frames its laws, and prepare for future legal developments. Rights are not just about possession. They're about defense, strategy, and understanding the framework within which they exist. At its core, this so-called urgent warning is not a threat in the sense of revoking rights. It is a subtle recalibration of expectations. The court is emphasizing that freedoms come with legal responsibilities, that historical context matters, and that modern regulations will be tested against long-standing constitutional principles. This is a turning point for Second Amendment jurisprudence. It underscores that while the right to bear arms is fundamental, it is not limitless, and its preservation requires careful legal defense and informed ownership. Ultimately, the Supreme Court is signaling that the next decade of gun rights will be defined not by sweeping legislation alone, but by careful litigation, historical argumentation, and strategic engagement. Lawful gun owners have reason to remain confident in their rights, but they also face a new reality. Constitutional protections must be actively understood, preserved, and defended. In this evolving legal landscape, staying informed and proactive is the best strategy for ensuring that Second Amendment rights remain robust, respected, and responsibly exercised for generations to come.